Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your out-of-frame host. Oh my goodness, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And it's the day before Thanksgiving. It is my favorite holiday, and I have many thanks to give. I'm not going to bore you with all of my thanks on the show. I'm not going to bore you with my legion of thanks on the show. Of course, I will just thank on the show who is relevant, I guess, to the show for thanks, which of course would be to all of my guests and co-hosts and various things. Yeah. And the people who get sued and the people who are suing and all of that, who make the content possible. But really, oh no. Oh, that was not good. There we go. Fix that. But really the thanks is to you, the chat. It's always the chat. It always comes back to the chat. And the chat always wins. Always, always, always. So thank you all for hanging out with me this past 2 years. I've been doing this now over a little over 2 years. It's a fun job. It's a fun job. I've gotten to do things that were never in my playbook. So I have to be thankful to that and thankful to you all for making that happen, making me show up here worthwhile. Because I mean, I could sit and scream at my computer. I do that anyway. But screaming at my computer with you is more fun. So, cheers to you guys. That being said, I did order the rest of my PC today. It will arrive on Friday. So keep your eyes open for an announcement of a Twitch live build, Boomer Building the Computer Webs or whatever, where I will be piecing together this massively overpriced PC. Perfect for end cap for 2019 is to buy a business expense and before tax time. So that'll be nice. But I will be putting it together live on Twitch. You can come make fun of my thermal pasting skills and all of that. Whatever you feel like you need to do. Whatever you feel like you need to do. Friday, I don't know if that's going to actually be on Friday. What I do know is going to be on Friday. What I do know is we're going to have some semblance of a big brain panel. Not all of the big brains have confirmed yet, but we are going to have a big brain panel on Friday, Black Friday. I believe that, unless I have to cancel it before then, but this was not proposed by me, so I'm super excited. Love talking to those guys, and we will have a big brain panel. So you guys can come and hang out with us, listen to us complain about various legal things, and should be a fun show. So I have, as you may or may not know, I have thrown a gauntlet down to Mr. Ty Beard. And as far as I know, Mr. Ty Beard has not done anything about it yet. So I'm not calling him a coward yet, but I might be calling him a coward. So we'll see. I'm waiting to see if he shows up. We've got the reason I'm waiting to see that, of course, is I called him out. Here is my friend's GoFundMe, Mr. W's Classroom Library, which I would have stopped talking about, but you guys have kept supporting it, and now we're within spitting distance of the goal. So I think it would be a great Thanksgiving gift, I guess, to boost that over the $10,000 goal. I have called upon Ty Beard. I said I would match his donation up to $500 to get this thing over the goal. I don't know what he's I don't know. We'll have to see. We'll see if he shows up to help out. But if you guys are interested in helping out that GoFundMe in our final push to just boost it over the $10,000 for Thanksgiving, that would be wonderful and much appreciated, and much thanks would go to you, of course. But I'm calling out Ty Beard, who is not, I don't think he's in the chat or anything. So we may have an anticlimactic end. We'll see. Of course, we will be talking about this GoFundMe for the majority of the time today. Vic kicks back $264,201. It's weird to say $201 because you end with one and then dollars. But no, we've got $264,201. And thank you. A couple people have even donated already today. We've got Richard Corwin. We've got Anonymous. Sean Nutt. Anonymous. Erica Smith. Alexander Achter. Raymond L. Anonymous. Brian R. And Alyssa Flutie. Some of those were in the last show, but I never remember exactly where they were. But yes, thank you all for those donations. And of course, a huge, huge Thanksgiving thank you goes out to everyone for this. We will be referencing this as we go. The plan for the show is to, let's see here. What is this? The plan for the show is to go through the remaining filings related to the fees and sanctions. We went through one yesterday. Hold on. Sorry, I'm just organizing things in the background. Went through one of those yesterday. We've got two of those that are going to be likely substantially similar. Classroom has hit 10K? What? I'm hitting Control F5. I'm doing it properly. Just a second. Let me get up hate doing it this way. All right. Hold on. Holy cats! Well, let me pull it over there. Where are we? That's the button. Look at that. We're at 10,850. 10,850. Here we go. We've got big donations coming in from, oh my goodness. Look at these things. Okay, so we'll go back. Jake Frazier, yesterday, $200. Thank you. Anonymous, Lauren Bibbs, big donations. James Ketter, Anonymous, a big $500 anonymous donation. We've got Nick Sykes, Dan Hughes, Kyle Slamma with a $500 donation as well. Sam Bonin, Randall Hernandez, and James Fleming. You guys are outrageous. You guys are outrageous. And now I feel like I'm going to have to donate, but I'm going to make Ty match me. I'm going to keep calling Ty a coward. I'm going to keep calling Ty a coward until he shows up here like a man and accepts my challenge. I can't say man's up. you guys are ridiculous. This is such a boon to these kids, and importantly, not just to these kids, to, you know, years of children going forward. So thank you. My challenge still stands, and even if Ty doesn't show up, I will match something. But we're just gonna mock and ridicule Ty until he comes out. Which brings me, this actually brings me to one of the subjects we're going to cover, and we will get into the documents in just a little bit here, guys. But I want to bring up something. Where is... I want to bring up something. Where is it? Oh God. Is it? No, I don't. This is not what I want. I was going to bring up a comparison. A comparison to what you guys have done versus what Ty, not Ty. Jamie Markey. I don't know if you guys remember. She had a little bit of a GoFundMe fundraiser for the SCESA. That's what it was. Let's see if they have that. Did that thing get shut down? No, there it is. Oh gosh. Here we go. We had some team fundraising done by the ever competent, super charismatic, most likable person ever. So likable that a 7-Eleven employee refused to save her from being accosted today, apparently. I don't know. But let's take a look. This is Jamie Markey's GoFundMe. Voices Without Fear for the SCESA. Now maybe she's hampered. Notice she created this a mere 6 days after what was that other one called? This was 7 days. So a week after. A week after I created Vic Kicks Back, Jamie Markey bravely created or partnered up Jamie Lynn. I don't know who Ali C is, but partnered up to bring money to the National Organization of Sisters of Color Enduring Sexual Assault. I mean, never mind that they were investigated by the IRS and found to have misappropriated $2.3 million worth of government grants. And never mind that they just sent a big FU to the government in response. But through sheer force of charisma, they were able to raise not even their entire goal. I want to point out that you guys have smashed the goal of a small fundraiser for for a teacher in a classroom in Minnesota. By almost, and by the end of the night, I don't know what's going to happen. We might have tripled Jamie Markey's effort for a national organization against sexual assault with allies like Jamie Markey. I don't know how you can ever succeed in life. But But we may actually end up tripling the amount that she was able to raise with her stunning and brave, massive following and huge reams of popularity. And we are going to talk about her 7-Eleven trip today as well, because I don't know about you. I don't know if you guys have seen this. I don't know if you guys have seen this, but oh, I got to read these, of course. We've got Sean Nutt, thank you. Anonymous, Philip Erdeljohn, Anonymous, Noe Arizmendi Vie. I hope I pronounced that right. No, it's probably no. Arizmendi Vie. I apologize if I massacred that. Thank you so much for your donations. We have just absolutely crushed it. Thank you so much. And we're gonna go through Jamie Markey's story as well, because if I just go through the documents, look up for Ty Beard's post. Ty, oh, are you in the chat? Ty, wow, welcome to it. I was calling you a yellow-bellied coward, but now that you're here, Mr. Ty Beard, if you look in the description of this video, you'll find a link to this GoFundMe. I had challenged you to help me get it over $10,000. As you can see, you are late and gay, so we have exceeded that already, and I haven't contributed, neither have you. So I had challenged you yesterday to match me, or no, that I would match you up to a $500 donation to this library, so we could get it over the 10,000 mark. Now it's over the 10,000 mark. The chat is so exceedingly generous that I don't know what to do, but my challenge has been thrown down. So, you know, I'm just waiting for you to reciprocate. Once I see your donation in the GoFundMe, I will be obliged to match it as per the terms of the agreement. This is a unilateral contract. So, yeah, your manhood is on the line. Your attorney license is on the line. I'll have you disbarred. I'll have you disbarred hard. You think I won't? You think I can't do it? Ho ho ho. Ho ho ho. You think he probably thinks I can't get him disbarred. We'll get him disbarred if he doesn't, that's the threat. I'm pulling the strings here. Oh, someone said to go look again. And what do we got? Oh God. See how this one's doing. Oh, we're at $11,165. We're still we're still checking it out. By the way, Ty, since you're here, while I've got you here. Ty, I noticed that you have scaled back your vacation. You were going to be gone the entire month of December. And now, like some sort of workaholic, you'll actually be around for a chunk of December. So, I'm kind of curious about that. It seems you'll actually be at the office. Are you worried about something, Ty? You worried? You must be, because I'm going to interpret everything as your fear until I see your donation. You must be afraid. Look. It's afraid. It's afraid! So there you go. Let's do the feel good stuff first while we wait. I'm going to go ahead and whatchamacallit? I'm going to go ahead and pull up the let me see if I can get the Jamie Markey. Tweets and replies. Oh wait, no. I need to do this incognito. Oh, come on. Hold on. Just, oh my gosh. Even her Twitter is too fat to fit on my computer. Here we go. Here's where it starts. Here's where it starts. Because I'm going to have to correct some of this. Lol, woman we've been incessantly harassing gets harassed in public, so now we can make fun of her some more because we're the good guys. Yeah. Okay, let's talk about this pumpkin. Emphasis on the roundness of a pumpkin. First of all, no one's harassing you. No, they're mocking you. They're ridiculing you, but no one is forcing you to read it or do anything about it. You've blocked everybody on Earth. So, yeah. Yeah. Nobody's bringing this to your door, so to speak. Nobody's bringing this into your household other than you. You could just turn off Twitter. You do that. You go into protected mode. You can do whatever you want. It's up to you. I don't encourage you to do anything. I don't care. But when you run out and badmouth someone with a false allegation, and then anybody who even questions you, you suggest is a woman hater and blah, 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 and you're a tough female and all of that cool stuff, which I support. I support the tough female thing. Go for it. And then you complain about getting accosted in some way outside of a 7-Eleven. Let's see what happens. Look at this. How many times can we tag 7-Eleven? So we've got one. Oh, here's the thread. The joy of being a woman. I gotta wonder how many actual women have this experience at any sort of regular basis. Jamie Markey seems to run into this a lot, and it makes me wonder if maybe she has an abrasive personality that fosters this. But maybe I'm wrong. Maybe all women. Maybe yes. Maybe hashtag yes all women have this happen. Ladies in the chat, you can let me know. Hey 7-Eleven, what's your protocol for when a man loitering outside, loitering is an accusation of some sort of criminal offense, screams verbal abuse at a woman entering your store, then follows her inside, continuing to harass her as she buys your goods, and follows her back outside? Because when I asked for help, your staff did nothing. We're going to talk about 7-Eleven staff in just a minute, because this is the epitome of fatso privilege, the absolute pinnacle, and we've got to talk about it. Because she goes in to buy a 30-pack of ho-hos to eat before she gets to the next 7-Eleven, and she's mad that she gets accosted by some guy. To quote what the stranger says, "You're a filthy dick-sucking bitch." Strong words. Strong words. Not my words. That's a quote. I'm quoting Jamie Markey quoting some other guy. He was not very creative, as he only shouted various versions of those particular words at me over and over. I had to defend myself because literally no one else present would, and he would not be ignored. Why should anyone, first of all, be obligated to defend you? Why on earth is literally no one else present would defend me? Why do they have to? Why did they have to? Second, how this is the weirdest story. I don't believe a minute of it because I can't imagine this. Like, is this person mentally ill? Maybe. Maybe she's mentally ill shaming someone or whatever. I don't know. Hold on. Maybe she's maybe he's mentally ill. I don't know. Very weird to see this, but usually you don't have a stranger unprovoked screaming at some random woman, you're a filthy dick sucking bitch. Like, that is really, really a characteristic for normal human interaction. I'm not saying it doesn't happen. I'm certainly not. It's just whenever I see an unprovoked aggression, presumably in daytime at a public place, from complete strangers, I'm immediately questioning what happened in the 30 seconds before that line came out of his mouth. And maybe nothing. I don't know. But so then she follows up. Is it 7-Eleven company policy to ignore customers' obvious safety concerns and requests for help? I would like to know if I need to stop going to all 7-Elevens for my own safety or just that particular store. Well, I mean, 7-Eleven is obviously intimidated by the fact that she makes up at least 12% of their global business. Let's find out why 7-Eleven employees might not want to really care. Let's see. Let's just type in this simple Google search as to why the 7-Eleven employee might not at all care about privileged white lady. Remember, Jamie Markey is a white woman. Even by her own standards, the second most privileged class on the entire planet would be a white cis hetero woman. By her rules, she's the second most privileged class of people on the planet. But here we go. So if you just type in 7-Eleven employee killed into Google, as I have, you'll come up with about 1,960,000 results. Let's just read the top ones. Dispute ends in fatal shooting of 7-Eleven worker. 7-Eleven employee fatally stabbed in Gaithersburg. Shoplifters wanted for running over 7-Eleven worker. 7-Eleven clerk shot and killed in Oakland Park. 7-Eleven worker killed in cold blood, police say. And most of these are different. This one and this one are the same. This one's different. This one's different. This one's different. 7-Eleven settles in death of hotel worker. Oh, this is a Chicago hotel worker who died after being knocked unconscious outside of a 7-Eleven. Video shows killing of 7-Eleven worker over stolen hot dog. Does a 7-Eleven worker have any desire to get flat murdered by some guy accosting Jamie Markey? No, of course not. Of course not. Oh my God. Why would he care at all? I mean, hopefully, if someone's actually being abused and accosted, you know, someone will step in and say, hey, knock it off. But I can certainly see why a person who like can just look at their life expectancy drop just by accepting a job, I could see them just going, sorry, I don't really care. So, many of my friends have worked at convenience stores. I never did. Thank goodness. And it was all like, even in tame suburban areas, convenience store workers always have a story, especially if they work an overnight. This is just the epitome of privilege. And I found it very funny. What? See. Anyway, so the grand irony, I'm going to imagine the 7-Eleven employee was a man. I think, I don't know. I'm going to just assume that the 7-Eleven employee was a man. And I'm going to assume that Jamie Markey ran to a man to protect her. A man didn't protect her when she demanded it, and now is mad at men again. It must be a tough life to be her. How dare a man I don't know intervene when another man I don't know is doing something I don't like? Here's the thing. If you are outside of a 7-Eleven, I'm going to give you a pro tip. This is legal advice or whatever. If you are outside of a 7-Eleven and someone is screaming various offensive things at you, get back in your car and leave. That's my thought. Like, if I got out of the 7-Eleven and the guy's like, yo, what's up? I'm gonna kill you. I'd be like, yeah, well, peace. Get back in the car and drive away. I can go to the next gas station. I could go across the street. I could go literally anywhere other than where the crazy man is. I don't have to be followed by the crazy man into the 7-Eleven. I don't have to demand someone else stand up to the crazy man on my behalf. I don't have to do any of that because I could just go away. What? Why is this foreign? Oh my goodness. Does she have any more talk about this? I mean, I don't know. Oh God. It's hard to talk about my hard knocks. It's really hard to actually look through her tweets because I can't go to tweets and replies in incognito mode. It doesn't let you. And being banned. Being banned is difficult. So, anyway, let's see. So, what? Why? Oh my goodness. Can you see the info of those who super chat you? No. No. I can see your screen name. That's it. YouTube processes all that. So let's see how we're doing here. Oh, hey! There we go. There we go. We have, let's see. We've got Ty Beard, $200. We have Anonymous at $50. Craig Picone at $100. Travis Muir at $50. Thank you all so much. And it seems like Ty has thrown down the $200 challenge, which I will now be obligated by blood oath, to meet. and a sincere thank you to Mr. Ty Beard for that. And I will pony up right now. And then right after I pony up on that, I'm going to we're gonna hit the super chats and hit the documents. Now, just as a reminder, this puts my total donations at somewhere in the neighborhood of $1,600. So, not to humble brag. And I'm happy to do it. This is how I believe we should do charities when able. Not everybody is able to do that, but when you are able to and you're asking people for money, and there's not some restriction on doing it, I do believe that you should offer to somehow match or help out in some way, right? Like you should put your money into things you claim to believe in, and I am doing so. I am doing so. So here we go. Oh my goodness. Let's see. Oh, I'm glad I don't have this screen up right now. I just had to double check and make sure, like, am I putting my credit card number up on screen? What the what's going on with this? Hold on. Somebody's giving me trouble. Trouble with a capital T. Let's see. There we go. Okay. Skip. Back to campaign. There. Here we are. All right. So I have matched it. As stated, I would match the donation of Ty Beard. $200 has been matched. Thank you all so much. Thank you all. Really has been fantastic. Your support for this project is blown away all expectations and hopes and even stretch goals. The $10,000 was a lofty goal, and again, I can't thank you enough. So cheers to you guys. Cheers to you guys. So we will I will force Mr. Wetzler to come back on and thank you all personally at some point in time. Okay, let's get back to super chats and let's get to documents. This is enough screwing around for the day. Can't sit here and horse around. We got work to do. What is happening? How's that? I don't have a backup right now. Okay. Can't you do anything more about the ban? What ban? Are you talking about Twitter? No. No, it's become quite clear that Twitter is not looking to have me back, which is a shame because I didn't actually violate the rules that they said I violated. So, but that's how it goes. That's how it goes. You know, when you play the game, it gets real in them streets. All right, let me pull up the documents we've got here. And where is, oh my gosh. How horrifying. Oh boy. As for other subjects that people are routinely asking about. When there's a transcript of the hearing available, I will go through it, of course. Hey, Ty, while you're still here, rumor has it, someone says that you screwed up your vacation letter, and since I don't know what their issue is with you screwing up your vacation letter, or what they think the result would be, but Mike the Tuba Dumford has apparently made a big deal out of screwing up your vacation letter, because that's what happens is you screw up a vacation letter. I'm not gonna bother buying it, but let's see. What is there to complain about? It's just a letter saying when you won't be around. Oh, God. Okay, anyway. Let's go to... Where's my purchases? Yeah. There's a way to... Never mind. Oh, I downloaded all these anyway. What am I doing? I think. Let's see. Nope. Okay. So we've got the motion. This downloaded. This is going to be an interesting one. Response to Funimation. I think there's going to be a lot of duplicated segments of this, but we will soldier through, because that's what we're here to do. You don't get to just assume that because it looks the same, that it is the same. You still have to go through and actually slog through the document and make it happen. Okay, so we have these 3 documents. All right. all right. Hey, what's up, Bob the Troll King? Oh boy, Dunford is a real winner. Since Ty isn't on the show, by the way, let's get back to the main issue here. Holy cats, we are trucking along over here as well. We're at $265,153. We've got Dominic's Lose Skunt. Dominic's, that is an interesting name. I am curious as to the national origin of your very legitimate naming scheme. It seems like a fine culture. Stacy Dealman, thank you for your donation. Matt and Mark, thank you. Michael S. Cybertaz Steffens, thank you. Travis Meir and Megan Kirby. Rhett Hypo, Joe Stonebreaker, Richard Corwin, Anonymous, Sean Nutt, Anonymous, Erica Smith. I think we're back at the ones I read earlier. Thank you guys so much for your donations. Travis Meir with a huge donation, $789. Holy cats. Thank you all. I really do appreciate it. Now let's we've got the documents pulled up. We're going to start with Jamie Markey. Since we're talking about Markey a minute ago, we're going to talk to her documents. But first, I do have to, by obligation of my independent contract with you guys, I'm going to read through the super chats. Blitzky says, as the Fuhrer, we at Lemoyne Company, and it's pronounced Lemoyne, strive to deliver the highest quality consulate experience at a reasonable price point. That's not just a promise, it's a lemon pledge. We've got Christopher Sanford says, challenge to the chat, send $8 donations to the GoFundMe as a direct statement that Funimation lost your sub. Lost your sub. Yeah, that's a great one. $8 donations to the GoFundMe to let them know, to let Funimation know that they lost your subscription. And if you really want to icing the cake on that one, with your $8 donation, whenever you do a donation to a GoFundMe, 1 second here, I gotta fix a window issue. Whenever you do a donation to a GoFundMe, you have the opportunity to share your donation, the information about it with everybody. If you want to do a final big middle finger to them, go ahead and make your donation for $8 and then share it on your Twitter or your Facebook and say, by the way, Funimation, you lost your sub. You lost a sub. If that's true, of course. If that's true, that would be fantastic. I think Funimation thinks that they're still getting out of this without anything. You know what I can't wait for? I'm already planning my 2020. And my 2020 plan is that the appeals court will overturn literally any one of the charges. Any one, it doesn't matter. 1 out of 17 is absolutely enough, in my opinion, for some serious comedy to ensue. If even one of those charges gets overturned on any of the defendants, Funimation is suddenly open to discovery. Even if the Funimation ones remain dismissed, they have information about all of these people and their communications. They have information related to the potential conspiracy. They have information related to the nature of the termination. So it seems like 2020 has a high probability of some Funimation depositions. And oh my God, I cannot wait. I cannot wait to share the deposition of a Funimation executive, Funimation staff. I can't wait to share it with the world because I think it'll be really interesting to see what they have to say about the situation. Oh boy. Oh boy. I can't wait for 2020. Oh boy. So anyway, let's move on. JCF Data says, I donated $250 of the $500. Match it, Nick. My challenge was to tie. And I have matched it in course, but thank you. Thank you. Random Blaze says, right now we have Shane Homelessberg spurging on a bunch of Twitter users after posting a picture of his DL. Oh, his driver's license. A lot T. Lawtwit self-spurging at the fact that Ty filed amended vacation notice. What is wrong with amending? Well, I was going to be on vacation. I'm not going to be on vacation. I'm actually not going to be on vacation when I thought I was. So here you go. I'll be around. What on earth has changed? No one's made a hearing request. No one's done anything that actually impacts. That actually opens up time for any last minute hearings that might come up. So that's very weird. You'd think they'd be happy. What are they even griping about? Oh my God. This just goes to show how disingenuous they are, right? Nothing anyone who's pro-Vic does can possibly be right or even innocuous. It must be ruined, nefarious, bad, awful, a screw up, something. That's the mode they're in. It's the mode of total dearth of honesty or dearth of intelligence. One of those two, not mutually exclusive, could definitely be both. Let's see. Broly fan 24 says, here's a 20 for Thanksgiving. Hey, thank you. Hope you and your family have a good one. Also, Epstein didn't Minecraft himself. I agree. Random Blaze. Did I find out that one of Epstein's guards was female? Which this is not a criticism in any sort of way or even a statement, but I just blindly assumed that a maximum security guy on suicide watch, I assumed that in a male prison would be guarded by men. Now I know that females work in prisons that are male. I know one of my relatives was a prison guard for something like 20 years, and I know I met many of his coworkers who are female, so I understand that happens. But I didn't realize that Epstein's guards were female. But I saw a picture of one of them. They've never actually gendered them in any of the news stories I saw until the picture of one after they were indicted showed up. So very interesting. Yeah, I know they do, Freighter. I'm not. I said it's not weird that it was a female guard watching male prisoners, but since they hadn't gendered them at all, my brain went straight to male guards. Also, I figured the fall guys would be men. I mean, the people who are going to take the heat from whatever billionaire had Epstein Minecrafted. The ones who are going to take the actual punishment for what happened, that would be men that they would put that on. So imagine if they had nothing to actually do with it consciously, and they're going to end up Seth Riched just by happenstance. Man, that's a raw deal. Random Blaze says ANN also admitted on using Low T Greg and Shane as sources for their new article. Oh man. And I read that article. It was a great job. Maybe we'll read it later if we have time. Ryan Mercado says, geez, Nick, whoever made that thumbnail, you're a damn god and very brutal. That was King Brawley. Also in Lemoi's voice, another live stream. Time to charge my clients another 10 grand. Hashtag gotta griff my clients. Pound me what, son? Pound what, son? Hashtag what, son? Either way. No, Lemoyne doesn't want anybody watching these live streams anymore. No more. Maybe he doesn't want anyone watching them because his clients are having to pay for it. And they're like, what, couldn't you just have someone else watch it, like summarize for you or something? Why do I have to pay for that? Maybe that's what's happening. Or maybe he's just depressed because he totally didn't get his ass handed to him by the judge. Perception Check says, Jamie Markey is the disgusting sort of slime that doesn't have an inkling of what a real victim of sexual trauma goes through. She wears her victimhood like it's the hot new fashion. She's a garbage human being. I agree. Brian Natterin says, please, Nick, use Jamie's maiden name of Karen. Let us not be rude. As always, thanks for keeping a trucker awake. Hey, my pleasure. My pleasure. It's a service I offer. RZEQDW says, friends worked at KFC when a guy with a machete came in and hogtied them all in the back room before robbing the register. In calm, safe suburbs. Plot twist. Turned out the guy was their manager. I assume he's in jail now. No, that's just a normal KFC manager from what I hear. Archangel Nishan says, this is all true, Nick. As an overnight clerk in a town of about 5,000, things do really happen in the middle of the night. Craziness. Of course, because meth exists. Bob the Troll King says, I may have done it again. Also, chat, you all rock. Finally, Franco Miranda says, just turned 29. This week has been an interesting development in the Vic case. Thank you so much for the continuing coverage and for the quality. Fire. A toast to you, Nick. A toast back to you, Franco. Thank you. And that is where we are. Let's get moving. King Brawley, you can shill your Twitch, of course, in my chat. You can't link it though, because links are disabled. But it's twitch.tv/King Brawley, I think. You can type that in. Catch you later, Tybeard. Have a good night. I'm about to rip up your team's documents. Rip them to shreds. Thank you for not chumping out on the challenge. I really do appreciate it. All right. Victor Mignogna versus Funimation, blah, blah, blah. Plaintiff's response and objections to defendant Jamie Markey's motion to determine sanctions and attorney's fees. We're going to burn through this because I have a feeling it's really similar to what they filed against Lemoyne, but I'm gonna try and highlight the differences as best as possible. Plaintiff asks the court to deny Jamie Markey's motion to determine sanctions and attorney's fees regarding the attorney's fees that are in excess of a reasonable attorney's fees. Plaintiff asks the court to deny defendant's request for additional sanctions against plaintiff because such a sanction is not necessary to deter plaintiff from bringing similar actions. Further, defendant seeks these sanctions only to punish plaintiff for his public participation. Additionally, plaintiff opposes and objects to defendant's billing entries for costs and attorney's fees offered by defendant in support of defendant's motion. As detailed further herein, defendant's billing entries include block charges, insufficient information due to heavy redactions, and fees for tasks that were duplicative, excessive, and unnecessary attorney work. Accordingly, defendants' billing for attorney's fees require a reduction of no less than 30%. Now, mind you, they asked for 80% against Jay-Sean. Response to request for attorney's fees. Plaintiff opposes defendant's request for attorney's fees and costs on the grounds that the fees and costs are in excess of a reasonable amount. TCPA requires an award of only reasonable attorney's fees. A reasonable fee is one that is not excessive, extreme, but rather moderate or fair. Sullivan versus Abraham. This is all the same. This is all actually looks like a word-for-word lift for most of these things, including paragraph 4 here. Determination is based on L. Apple 1 Limited versus Olivas, citing Dinkins versus Calhoun, and referencing the Anderson factors. I'm going to try and summarize some of these so we actually do get through the documents, because that's the main thing. We want to get through the documents. Oh, these are not watermarked by the thread knot. I procured these on my own. Court then multiplies the number of such hours by the applicable rate, product of which is the base fee for Lodestar. Relevant factors in making determination of reasonable attorney's fees are provided in Arthur Anderson versus Perry Equipment. Here are the factors. We went through them yesterday, but real quick: time and labor required, novelty and difficulty of the questions involved, in the skill required to perform the legal service properly. Likelihood that the acceptance of the particular employment will preclude other employment by the lawyer. Fee customarily charged in the locality for similar legal services. Amount involved in the results obtained. The time limitations imposed by the client or by the circumstances. The nature and length of the professional relationship with the client. The experience, reputation, and ability of the lawyer or lawyers performing the services. And whether the fee is fixed or contingent on results obtained or uncertainty of collection before the legal services have been rendered. There was a hot take on Twitter by one of the Spednots, I won't mention his name, saying that you realize, of course, that since the judge only awarded $50,000, that the judge determined that was all that was needed, and that's how bad the case was. No, that's actually not what that means. And you know that, which is more embarrassing, that you're trying to salvage some sort of gotcha over Lemoyne being shafted out of like 170 grand and Volney being shafted out of 120 grand. Like, I know you're really trying to salvage that narrative, but that's what actually happened. Those guys either overbilled their clients so egregiously that the court had to intervene on behalf of the client, or that's putting it a little bit harshly. The court determined that $50,000 was required to win this case because they did a bunch of unnecessary tasks that they elected to do. Now, that doesn't mean that the case was particularly better or worse. What it means is they opted to do a bunch of work that wasn't necessary. Not because the case is bad, but because they chose to do unnecessary work, like watching YouTube, like having meetings with co-defendant counsel that might actually be opposed to them on various positions, like duplicating phone calls, like duplicating drafting while simultaneously filing things. There's a whole bunch of stuff that went into that. And I know it's really cute to say, hello, Vic's case was so bad. First of all, we'll see what the appeals court says. At the end of the day, they're the ultimate authority on, well, the Supreme Court's technically the ultimate authority. The likelihood of a petition for cert being granted the Supreme Court is low. So the appeals court is much more authoritative, we'll say, and may end up being the ultimate authority on this. Until they rule on both the outcome and the fees, none of this matters at the end of the day. But pretending that getting that 50 grand was like a big win for Funimation or Monica and Ron is obviously, that's the cope. That's the cope coming through as hard as it possibly can. Keep trying to spin that narrative. Unfortunately, since you blocked everybody and you guys aren't interesting, you don't have enough followers to really make it stick. But best of luck to you. You'll get it eventually. The movement seeking fees bears the initial burden of submitting adequate documentation of the hours expended at hourly rates. The applicant should exercise judgment with respect to hours works and should maintain billing time records in a manner that will enable a reviewing court to identify distinct claims. These are the same sort of cases here, or same language from the previous one. We probably need to get down to their specific fact section to get into new stuff. Here they bring up Stokes, which reduced fees from over $100,000 to $44,000 based on there were unreasonable fees, and the fees that were submitted were not properly supported by documentation. Specifically, this is the important line of the paragraph. Defendant pursues a strategy of monitoring and attacking public statements made by plaintiff and non-parties and seeks sanctions as a means of silencing plaintiff. Right, they're trying to improperly use the sanctions and attorney's fees to discourage Vic from public participation, which they've actually discouraged Vic from public participation the entire time. One, by ganging up and bullying him. Two, by defaming him. And three, by threatening to use his existing very limited public statements against him in a legal argument. And actually doing so. This is why the public figure doctrine is actually kind of a trash doctrine. Because it chills the ability of a plaintiff who is questionably a public figure, and actually any plaintiff, from participating in their own public defense. Like imagine you're not a voice actor. You're just a guy, right? You're just a dude or a lady. You're either a dude or lady, and you are out and someone defames you on Twitter. And then you go to Twitter to say, no, I didn't actually do that. And the court determines that you have participated publicly in this conversation. And now, as a limited purpose public figure, you're entitled to less protection of the law than someone else. You're not Tom Cruise. You're not even Vic. You're not even like a boring Rekieta Law. You're just a guy. You don't have any particular platform. Maybe you have 100 Twitter followers. It doesn't matter because that's a community and you have participated publicly in your own defense. Public figure doctrine needs to be reevaluated heavily because who participates in their own defense? Hopefully anybody. Hopefully anybody. We have a society predicated on the idea that you don't have to publicly defend yourself because you have due process. But we've thrown that away for all practical purposes. We just got rid of that. And now people who don't publicly defend themselves to our required standard are automatically guilty. Yes, we live in a society. I will use the meme as often as required. But it's ridiculous to assert that someone merely speaking out in their own defense is now a public figure. But that's how it is. That's how it goes. That's how this entire case has been framed. And it really chills your ability to engage in your free speech just by the nature of you being accused of something false. So that's great. Defendant seeks to recover attorney's fees for its endeavor to deter plaintiff from his own public participation, rather than offering any evidence that shows that additional sanctions are necessary to deter plaintiff from bringing similar actions described in this chapter. In total, 30% of the awards sought by defendant for costs and attorney's fees are not supported by sufficient evidence. Defendant's billing entries include block charges. This is the same in the other one with Rormu's venture, citing this and suggesting that block charges are not sufficient because block charge is, here's a block of time, say 5 hours. And the block charges are variable. You can block charge a half hour, you can block charge 10 hours. And then you say that in that 10 hours, you did this and this and this and this. But you don't say how long you spent on each item. You just say, I did these 5 things in 10 hours. Does that mean 2 hours each? Does that mean some of them took 30 minutes and one of them took like 6 hours? Don't know. So that's what a block charge is. And they are making the argument that the block charges prevent the court from sufficiently determining if the charges are valid. In a lot of cases, block charges are fine, right? Like you block charge a phone call, drafting, and submission of a document. Okay, cool. That took 3 hours. Now, if there's no questionable billing, or if the amount of questions is really minimal, and you're like, whatever, you don't need to question a block charge, right? You're not going to nitpick over the court trying to get rid of one fee. If say the total bills are like 20 grand and the block charges all kind of line up with what would be expected in the case, and maybe there's one thing where it's like phone call with so-and-so, and you're like, well, who's that? I haven't seen an affidavit from them. I haven't seen something. You're not going to really go after all block charges because of one errant sort of entry. It's the prevalence of the block charges and the inclusion of a bunch of presumably unnecessary tasks that are rife throughout all of these billings that are really bringing these block charges into question. That's why they're going after them. In the Barrow case, U.S. District Court for the Northern District of Texas analyzed attorney's fees involving block billing under the Anderson factors. Now, of course, District Court for the Northern District of Texas is not necessarily binding on a state court, although they may be interpreting the state law on this. There, because of block billing, it was impossible to conduct meaningful review and determine the precise number of hours that should be reduced in each time entry. Following an extensive review of the attorney's timesheets, court reduced each attorney's bill and the percentage of items that were too vague to support an award of attorney's fees. Several instances of block billing for every month of defendant's billing statements. Okay, these are going to be specific to this one. For instance, in an entry dated July 24th, 2019 for 1.8 hours, defendant described the task as redacted immediately. That should call everything into question. Receive and review plaintiff's objections to Funimation's evidence. This illustrates 3 problems common throughout defendant's billing entries. 1, lumping together several discrete tasks without specifying how much time was spent on each discrete task. 2, redacting so much information that the court cannot determine whether the task was reasonable, in this case, an entire discrete task. And 3, performing totally unnecessary tasks. To be clear, this indicates that Jamie Markey wants to recover attorney's fees for work spent reviewing plaintiff's objections to another defendant's pleadings. The contents of those objections are of no consequence to this defendant. Remember, they're co-defendants, not joint defendants. They're sued individually, and they do not necessarily, they don't share legal arguments amongst the three groups, the 4 parties. Contents of those objections are of no consequence to this defendant. They 1.8 hours allegedly spent reviewing plaintiff's objections to Funimation's evidence serve no purpose for defendant Jamie Markey, and the fees are not reasonable. A single entry on September 2nd, 2019 states that the attorney worked for 4.6 hours and describes the task as draft reply to response to motion to dismiss, receive and review second amended petition, revise motion to strike, various email correspondence with redacted. Not only are these tasks blocked together, and again with another task that is substantively redacted, but the attorney has blocked together the drafting of several documents. Defendant attempts to avoid the court's scrutiny on each of these tasks by bundling them together with a large number of hours. Considering the minimal effort required to sufficiently document attorney time on discrete tasks, these fees should be reduced significantly. Now, we do know that the court did not significantly reduce attorney's fees for Markey. So this was largely unsuccessful. And part of the reason is because I think, as I said, Sam Johnson's billing, even if it includes some questionable stuff, overall about 50 large is probably what you expect to defend against a defamation suit at pretrial. You'll find that number, shockingly, in some of my early videos. You'll find numbers throwing out around that area. $30,000, $40,000, $50,000, $60,000, even if it's dismissed, stuff like that they would be on the hook for. That's because that's just kind of the cost of entry into the legal system. Unfortunately, it's very, very expensive. Which is why I suggested maybe they talk to Vic's attorney and see if they could work out settlement and save everybody the hassle of all of this nonsense. I tried to help you. I tried to help you. Sage advice. I need liquor. Someone in the chat earlier mentioned that gin is better than vodka. I agree. And we're going to go with the Cosquay finished gin. That's this guy. Let's see. Just a second while I excuse me while I whip this out. Let's take a peek over here. We're at $265,401 on the GoFundMe. I needed this is an aged gin. That's why it's not clear. It has an amber color due to the barrel aging process. If you don't think gin is better than vodka, you're drinking bad gin. So we are at 265,401. Look at these eights. Look at these eights. Oh no. Oh no, Funimation. We've got Geo Funamore, $8. Manny Alvarez, $8. Anonymous, $8. Mark Mariansky, $108. Thank you so much. Jonathan Canfield, $8. Brian Coctavy. No way I can say that without smiling. $25. Thank you so much. Jermaine G, $8. Fan Advocacy Network, $8. Chris Hewitt, $8. Ramon Franco, $8. Jacob Buchanan, $8. $10 from Anonymous. Thank you so much. CJ F. and Henderson, $5. Greg Johnson, $8. James Taylor, $20. Thank you, James Taylor, for your music. And then, well, we read that one. Thank you guys so much. $8. Oh man, that's just from if you guys, I'm sure you guys do actually understand economy of scale and how it works, how those percentages translates to not just participation, but participation with donation. The fact that in how many minutes? We've got 30 minutes. We've got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. 11 people in 30 minutes on a random live stream in the middle of the night signaling that they dropped their Funimation subscriptions. Like, that indicates that the number of people who have dropped their Funimation subscriptions is significantly higher. The way it scales out, like the amount of potential people you have, the amount of people who participate, the amount of people who pay, buy into something, like how that scales out, that having 11 people show up in 30 minutes to talk about that is not promising for Funimation. That's a bad number. It's a very bad number. Good job on you guys. You guys are great. Okay, back to the document here. Where are we? This one. Defendant's redactions prevent the court from determining what task was performed. I don't like... This is a mild criticism of Ryan Seller. It's not even a criticism of him. It's a stylistic choice. What you'll notice that he does is he has subheadings, but they're numbered. So his subheading is here. Defendant's billing entries include block charges. That's underlined. So you know it's a subheading. And these next paragraphs are about that until the next underlined one. Defendant's redactions prevent the court from determining what task was performed. I personally like to separate out subheadings from the paragraphs. It's just stylistic choice. There's no yes or no. I just, you know, this is part of the stuff that goes into drafting. I like to separate it out. So what I would do is I would have this here, left justified, bolded, maybe even in a slightly bigger font or a slightly larger point size to emphasize the change of subheading. That's what I do. I find it being numbered is distracting. But, I mean, who am I? Just a guy. Okay, so the redactions prevent the court from determining what task was performed. In an attempt to conceal supposedly privileged information contained in the billing without providing a corresponding privilege log, the defendant has redacted some tasks so completely that the court cannot assess whether the task was reasonable or not. In some incidents, what the task was at all. Defendant's practice of redacting entire tasks combined with defendant's block billing practices leave the court with no way to determine the reasonableness or necessity of discrete tasks performed. See Mignogna versus Rauhauser. In Mignogna, the court considered an attorney's redacted fee statements where large portions or whole entries were redacted on the basis that they involved communications between client and attorneys. Court noted that the content of some of the redacted matters may have involved communications between attorney and client, but a trial court is not at liberty to blindly assume that fees for every communication between counsel and client should, in fairness, be awarded in a lawsuit. On the basis that the trial court should not have awarded fees for portions in which the trial court cannot determine the propriety of the fees, also noting that the attorney billed significant time for opposition research, the issue of fees were remanded back to the trial court. Defendant entries contain redactions almost identical to those addressed in Mignogna. Defendant's documents show entries throughout for, quote, phone conference with redacted, email correspondence with redacted regarding redacted. While the information may be privileged, the court cannot determine from the information provided whether the costs and fees were reasonable. In these instances, defendant's billing requires that these entries be reduced or removed altogether. Defendant's billing entries include duplicative, excessive, and unnecessary attorney work. A court can reduce fees for duplicative, excessive, or unnecessary attorney work on the grounds that such fees are not reasonable. They can reduce time for excessive conferences if they are unreasonable considering the complexity of the issue being considered. It should not be lost on the court that defendant is aligned with three other parties in this case, while defendant is and its co-defendants have acted in concert with one another throughout every step of this litigation. Defendants in this case are represented by 3 separate legal teams. For the month of August, defendant billed 7.3 hours of attorney time for conferences, each with the subject matter redacted. Each of these defendants seeks fees for months of conferencing amongst one another to the extent that each defendant's legal team needlessly duplicate tasks. Their fees for such tasks are subject to significant reduction. Defendant's fee statements, in addition to duplicating work across 3 legal teams, demonstrate duplicative and unnecessary attorney work. Defendant failed to establish the qualifications for its attorney's legal assistant. Under Texas law, legal assistant fees are a component of attorney's fees, and courts must consider a 4-step test. This is new. To assess whether legal assistance fees are recoverable, a party may separately assess and include in the award of attorney's fees compensation for legal assistance work if that assistant performs work traditionally done by an attorney. In order to recover such amounts, the evidence must establish the qualifications of the assistant to perform substantive legal work. Because you don't want to just have like, oh, this is my kid. My kid's my assistant because he answered a phone call. That the legal assistant performs substantive legal work under the direction and supervision of an attorney. Was the attorney reviewing the documents? Did the attorney direct them in some way on a specific task? The nature of the legal work performed, the legal assistant's hourly rate, and the number of hours expended by the assistant. In Gill Savings, the Dallas Court of Appeals considered whether sufficient evidence had been provided to support an award for legal assistance fees. Their fee statements include the date the service was rendered, a brief description of the work that was performed, the time spent performing the particular task, the initials of the person performing the work, and total amount due as a result of the services which were rendered, noting that the information provided did not provide any help in determining the qualifications, if any, of the legal assistants. 2, whether the tasks performed by legal assistants were of substantive legal nature or were the performance of clerical duties, and 3, the hourly rate being charged for the legal assistant. So the response to the request for sanctions. Here we go. Here we go. In addition to seeking attorney's fees and costs, defendant seeks a sanctions award that will account for the $260,000 GoFundMe against plaintiff and allegedly, quote, to deter plaintiff from bringing similar lawsuits in the future. Oh boy. They want to account for this. That $260,000 GoFundMe is now $265,433. And look at those 8s. We've got Wilbert Marquez Cuevas Rivera, Anonymous, and Anonymous coming in with the $8 donations. Thank you so much, bringing the total up to $265,433. No longer is it a $260,000 war chest for my con-slut. I wish my con-slut's chests were in my hands. Plaintiff asks the court to deny defendant's request for sanctions in its entirety on the grounds that the award will not serve to deter plaintiff from filing similar lawsuits, and because defendant seeks to use sanctions to punish plaintiff for his own public participation. One of the oversights in this, they've brought up the GoFundMe over and over and over. And they brought up that Vic endorsed, approved of, blessed, urinated on, and hugged the GoFundMe. He did that. Vic did that. Vic gets to engage in public participation. And what more public participation is there than the GoFundMe itself? It is a tangible, monetary expression of disgust for the defendants and support for the plaintiff, whom people believe should have the right to have a day in court before being socially executed. That's it. That's it. Some people are big supporters of Vic. Many contributors to the GoFundMe had never heard of him before this. Not once. But to punish Vic for the GoFundMe is to punish Vic for his very mild participation in the public forum. His ability to say, thank you. That's it. That's basically what he said, was thank you. And by the way, it's not fraudulent. That was the extent of Vic's public participation. The GoFundMe has not bullied anybody, by the way. The GoFundMe is not capable of bullying anybody. The GoFundMe has not spoken out on behalf of Vic in some outlandish way. It literally just provides updates, and it provides a place where people can support Vic. That's it. It's a vehicle. It's a vehicle. And these people seek to eliminate that or punish him for a vehicle that he couldn't have stopped, by the way. Not only did Vic, I guess he could have damaged it by by specifically calling it fraudulent, which would have been to lie. But as Vic said at deposition, I was making it either way because people asked me to. Now with Vic certifying that it wasn't fraudulent, you know, people were given some level of comfort. But all of the back end stuff, setting up the GoFundMe to go to the legal team, setting up all of that was done without really any of Vic participation. Like, he knew that it would go to pay his legal fees, and he knew, I guess I don't know how the Salvation Army thing came up. That was expressed later in an update. I clarified that that any excess amounts, I was told any excess amounts would go to the Salvation Army battered women's shelter in Dallas County. So like, I assume Vic was involved in that. But other than that, wasn't like communicated with me in how that came about or anything like that. So, Vic's participation was really minimal in determining how, or in actually affecting how this would work out. Basically like, Vic, people want to help you. I'm going to give them a way to help you. And, I'll connect it directly to your legal team so you don't have to touch it. Cause, you know, while I think it would be great if Vic came out and just said, hey, you know, it would really help if you guys would show your support. And I think a lot of supporters would really like him to do that. You know, I'm not in control of Vic, and you know, there's this great gulf of separation between me and him and the GoFundMe. Which is a damn shame, really, because it's because of these vampires that they prevent Vic from participating in his own defense. How disgusting are they? Anyway, let's go on. Defendant offers 4 reasons why this court should issue additional sanctions against plaintiff. 1, plaintiff said he may sue other people who he believes harmed his reputation. 2, a third party has raised funds supporting plaintiff's effort. 3, defendant objects to statements made about defendant in plaintiff's pleadings and the fact that court dismissed plaintiff's claims pursuant to the TCPA. And 4, defendant seeks less than its offered attorney fee bill. A trial court abuses its discretion if the sanctions awarded are greater than necessary to promote compliance. TCPA's purpose is to prevent the bringing of meritless lawsuits that discourage the exercise of certain constitutional rights. They consider the following non-exclusive list of factors to the extent they are relevant. These are low factors. We went through them. I don't want to read them. They're boring. That's citing Landry's. Lemoyne. I want to cite Landry's. I wish I could afford to eat at Landry's, but I can't, but I'll cite them all over the place. Defendant has not offered sufficient evidence or any evidence whatsoever to support sanctions based on these factors. An award of these sanctions requires a finding beyond the simple fact that plaintiff's claims were dismissed pursuant to a TCPA motion. There's no evidence of bad faith, willfulness, vindictiveness, negligence, or frivolousness on plaintiff's part. Plaintiff's alleged valid cause of action against defendants and alleged valid causes of action against defendants. Oh, he's got the bad defendants apostrophe again. And pled sufficient facts to support those causes of action. It is plaintiff's understanding that his claims were dismissed not on the basis that he didn't state viable claims, or rather the court believed the evidence offered was not sufficient to prevent dismissal under the TCPA. Again, this is an important distinction. This is a very interesting and good tactical choice at this point of the suit. Look at how carefully this sentence is worded. Okay? It is plaintiff's understanding that his claims were dismissed not on the basis that he didn't state viable claims. It doesn't state that plaintiff's claims were dismissed based on this, because that's a matter that's going to be on appeal. It's very, very carefully worded. Plaintiff's understanding that his claims were dismissed not on the basis that he didn't state viable claims, but rather the court believed the lower court, the evidence offered was not sufficient to prevent dismissal under the TCPA. It's a carefully crafted line, and I commend Ryan Sellers for doing it, because it doesn't admit that the court was right, but it defers to the court's authority in the present. That makes sense to you guys? I hope you track along with that. It defers to the authority of the court to suggest that this case should be dismissed and its reasons for doing so, but it doesn't state that that's proper, and it doesn't state that that's what happened. Only that the plaintiff is understanding the court's authority to do so. And that's great. Because otherwise, you know, and you're allowed to argue in the alternative, you're allowed to do those things, but it's always great if you can consistently maintain that while you acknowledge the through deference to the trial court's authority, you acknowledge the court's decision, you do not agree with it, you just understand how the court seems to have gotten to that wrong decision that they had the authority to get to. And now we're going to ask the Court of Appeals to overturn that. So that's how that works out. They mentioned the GoFundMe again. Well, I'll just take your word for it. Here we go. Back to the GoFundMe. We're at $265,550. We've got $88 from Anonymous. Thank God we don't have any. We don't have 14 $88 donations. We've got Derek Szymanski Jr., Marcus Hollis, Zach F., Jesse Fritz. Thank you guys for donating. We got 1, 2, 3, and 4 more $8 donations indicated. So thank you guys for the donations. Again, fantastic. We're up to 5.8K donors. That means we've got new donors still donating to this GoFundMe. Thank you all. And please remember to share it. Sharing it is devastating to them. All of this is devastating to them, and they hate it. Look how much time they spend on it. They hate the GoFundMe almost as much as they hate me, which is that's like TMTC, right? Too much to count. Mythos Irving says in Lamois voice, "Am I doing a good job looking up Sabbath's love juice off your con slut Monica's gunt, Ron?" Oh God, Mythos, why? Heath's GoFundMe is over 12K? No. Oh my gosh, 12,250. Big money from Bob King. Mark Mariansky again, and Matt King. Thank you guys so much for donating. You guys are ridiculous. 12,000. We're so dangerously close to doubling Jamie Markey's stupid effort. What? God. Oh, man. I want her help. I want her help promoting my GoFundMe. Okay. Apology not accepted, Mythos. That was disgusting. All right. Here we go. Defendant seeks to improperly infringe on plaintiff's First Amendment rights to freedom of speech and association by seeking sanctions based on plaintiff's public statements. Defendant complains about statements generally described but not particularly identified in plaintiff's pleading and motions. Moreover, she fails to explain how this goes to any culpability or vindictiveness on plaintiff's part in bringing the suit. Defendant's statements and briefing are brimmed with attacks on 3 public statements by plaintiff and non-parties. Defendant offers this as her basis for levying additional sanctions against plaintiff. Defendant has made most of her arguments in every pleading filed about a third party who has raised funds for the purpose of paying plaintiff's legal costs. However, as the various defendants, apostrophe, in this case have regularly highlighted, the fund is not payable to plaintiff. The existence of this cannot be considered regarding plaintiff's ability to pay a monetary sanction. Defendant has not offered any evidence whatsoever on this factor. Gee, guys, I wonder, do you guys remember the Speds of September? Law Twitter. Lol, 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 that GoFundMe's gonna sink Vic. Lol, 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 that GoFundMe. Oh, that's the biggest liability. Lol, 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 GoFundMe, 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 lol. It's almost like the GoFundMe was created by a lawyer with careful attention to how to keep the GoFundMe that would be mass flagged constantly, how to keep it up on GoFundMe, how to make it above board for any criminal inquiry, how to overdo it on caution in structuring how the GoFundMe would not only be established and maintained, but how it would be paid out. It's almost like a lawyer set it up, thinking ahead as to how it would be attacked, what the best course of action might be to preserve it for 11 straight months of attack. Wait, no, 10 straight months of attack. And remember, the good, smart, Mike fucking stupid Dunfords of the world all said that a dumb lawyer set the GoFundMe up wrong and it will screw Vic. All of them. The GoFundMe, it did nothing. It did nothing. It doesn't hurt at all. Oh, God, it must be embarrassing for you. It must be embarrassing for you to be outplayed by a drunk nobody lawyer in the middle of Minnesota, that you have been so ass blasted over how badly you called that one that it can't be understated. Not only did the total amount of fees not come close, not even come close to reaching, the total amount of fees is off by $30,000 and growing the amount of the GoFundMe. Not only that's all of the defendants, but the total amount of fees and sanctions combined falls short of the GoFundMe. And the GoFundMe appears to have had zero impact on this case in a negative way on the terms of fees and GoFundMes. You morons were out there trouting that and how dumb I was for setting it up, how I somehow screwed Vic. Turns out the stupid was all on your plate and you were shoveling it in the entire dinner. Good job. Good job. Good call on that one, Law Twitter. You guys are really banging it out. The worst part is the one part of this case that you've gotten right, you were wrong in how you got it right. That's the worst part. God, I can't wait for appeals. I can't wait. Sorry. The fact is, if plaintiff so desired, he could sue additional defendants who have harmed his reputation, but has not done so. Round two. Oh, big mistake mentioning round two. Big mistake. Except that, what did Ty say? What did Ty say about round two? We could file round two right now. We could file round two right now. But they haven't, though. It's like there's evidence out there that Vic could sue more people, but hasn't. In fact, it's almost like the defendants have made the case over and over again based on the wording of the GoFundMe. What's the GoFundMe's wording? What was that? This criticized GoFundMe wording mentioned in several pleadings. There are many possible defendants in different jurisdictions, from boring bloggers to multi-million, even multi-billion-dollar corporations. He said there are multiple defendants. They haven't been sued. They haven't been sued, though. You made the case that Vic is not vexatiously suing everybody he could. You made the case. You made it. You guys did it. You did it, Reddit. Now post a picture of yourself with a date on it or whatever and a dildo in your mouth. We're up to $265,587. Faisal Algadir, a much better Faisal than the other one. CJF and Henderson, again, anonymous Steven Steele. These are look at these $8 donations coming in. Yo Hawk, thank you guys for your donations. May they keep flowing. May the spite flow. All this brilliant legal work. Mike Dunford licking up the cummies of these lawyers. Again, watching other men do law. Watching their filings and saying that they're so great. Oh man, he's really calling out that GoFundMe. Oh, that's perfect. Oh man, Mike, how wrong you were. You were so wrong. God, it must be embarrassing. This guy wants to teach kids to be lawyers. He wants to be a law professor. Absolutely blown out by a rando in Minnesota. Go get your PhD, army husband. You're an embarrassment to the profession. You're an embarrassment to manhood. And you're an embarrassment to sweaters. Gross. All right. He's not done so. He hasn't sued the people that he could sue. They've referenced that thing so many times. He says there's multiple defendants. There are. They even tried to get him. They tried to force him to sue Mars Girl. They told the court that he should have sued Mars Girl. Why didn't he sue Mars Girl? He should have sued him. And then, of course, they go on to tell the court that suing other people would be vexatious. But he didn't sue them. He just sued you. Because you are terrible people. Moreover, such a statement does not support an allegation that any subsequent suits against people who harm plaintiffs' professional reputation would be subject to dismissal under the TCPA. Any sanction awarded on this basis would improperly deter plaintiff from bringing valid lawsuits in Texas state courts and impinge on his First Amendment rights. In fact, the record before the court on several of these factors weighs against imposing sanctions. For example, defendant has shown no evidence of prejudice apart from out-of-pocket expenses as a result of plaintiff's conduct. Also, plaintiff has no history of filing suits like this in the past. Sanctions award should be denied in whole or alternatively reduced. He said whole. So there we go. Ryan Sellers. Ryan Sellers, a very good filing. Some very good arguments in here. Definitely helped on the sanctions part of it. On the attorney's fees, I think Chup had just said, I'm going to set a $50K cap per defendant. That's what I think. Maybe Chup chose a different method. We'll find out when he offers his finding of facts and conclusions of law that has been humbly requested. Not tantrumly stamped for, but humbly requested by Jay Sean Lemoyne. All right, I'm going to go through puberty. I'm going to skip Funimation's brief, or the response to Funimation's fees for just a second. And instead, I want to do this other document because it's different. It's different. Where's your How Embarrassing t-shirt? I don't know. I told my art guy I want it. He's fired. He's fired. Actually, I think he's very busy today, getting ready for Thanksgiving. So, I want it back up on the store, and as soon as it is, I'll pin the link on the chat because I can do that. That's cool. That's cool. This is different. This is the plaintiff's objections to and motion to strike defendant's affidavits and exhibits attached to defendant's motion and brief for attorney's fees and sanctions pursuant to the Texas Citizens Participation Act. I think this is going to have a more thorough dissection of their fees, and so I want to bring that up. That guy from that thing, I hope you're saying thank you about the How Embarrassing t-shirt. Ruh-roh. Oh, Scoob. I hate when my voice cracks. I sound like Shaggy. But I eat sandwiches like Shaggy. Like they're like this tall. Oh man, that's great. This is not different. Oh, I see what you're saying. No, this is that. Did YouTube take away my 1080p privilege? It might be me. My stream settings might be outputting. I don't know if my Streamlabs should be set up to output 1080p, but it might have borrowed from, if you use Streamlabs across multiple devices, it shares their settings sometimes, and sometimes it doesn't. I hope not. I can't change it right now. Hawk Anime says, happy Thanksgiving, Boomer. Hey, happy Thanksgiving back to you. Guys, Thanksgiving is legitimately my favorite holiday. My favorite holiday. And I did this a couple years ago, and I think I'm going to do it tomorrow. Because it's my favorite holiday and no one expects this. I'm going to challenge / recommend. This is less of a challenge and more of a personal recommendation. Call me the sage old man for a second. I'm a sage old man. Do this for yourself. I mean this from the bottom of my heart. This is something that you will, maybe not. It's something that I found very, very rewarding. Go on Facebook. If you have a Facebook. Go on Facebook and tag. This is a weird thing. Tag people in your friends list or in your life. If they're not in your friends list, it doesn't matter. But if they're in your friends list, it's easier. Tag people in your friends list on Facebook or wherever that you don't normally talk about or do. Like, not like, oh, here's my spouse. I mean, do that, I guess, but that's expected. Tag people that you don't normally talk about and just tell them why you're thankful for them. It's a challenge because you have to sometimes like figure out what about that person makes you thankful. But it is one of the most rewarding things you can do for yourself, because first of all, you go through and you find out why you actually like people that you might not interact with as much. Second of all, you will make their Thanksgiving in a very small but very meaningful way. It's a really cool exercise. I encourage you to do it. Take an hour out of your day and just tag like 20 people. They won't see it coming, and they will feel an amazing, like you will change their entire day. And I can't stress enough, that's what Thanksgiving's about. It really is about being thankful for things. It's not about genocide and all that crap that the media is trying to shove into our faces. It's about being thankful for things and people. And so, you know, this is that rare sentimental side you'll see from me, but go do it. Go do it. I've done it a couple years. I'm going to do it again this year. I haven't done it in a few because I've been off of Facebook, and that's why they won't ever see it coming. It's like the perfect struggle snuggle. They'll never see it coming, but they'll like it afterwards. Yeah. So that is what I'm going to do tomorrow for part of my day, and I encourage you to do the same. So I'm thankful for no, you can't be Sam. Don't do it. Don't do it. Now comes plaintiff victim. So this is the objections to the motion to strike, or objections to and motion to strike defendants' affidavits and exhibits. So this is their billing and their affidavits about their billing. So now comes plaintiff Victor Mignogna and hereby files his objections to and motions to strike defendants' affidavits and exhibits attached to defendants' motions and brief for attorney's fees and sanctions pursuant to the TCPA. In support thereof, plaintiff would respectfully show the following. On November 4th, 2019, each defendant filed motions and or briefs in support of their request for attorney's fees and sanctions against plaintiff. Plaintiff objects to and moves to strike affidavits and supporting evidence offered by defendants in support of their request for attorney's fees, costs, and sanctions. The motion for reasonable attorney's fees, costs, and sanctions filed by defendant Funimation is 13 pages in length and has 112 pages of exhibits attached. Exhibit 1, affidavit of John Volney. Exhibit 1A, John Volney's resume. Exhibit 1B, Christian Orozco's resume. Exhibit 1C, Lynn Pinker Cox and Hearst invoices. Exhibit 1F, transcript of excerpts from YouTube livestream. That's me. I'm famous. Exhibit 1G, screenshot from YouTube livestream. Hope they got my good side. Exhibit 2, excerpts from deposition of Vic Mignogna. Motion to determine sanctions and attorney's fees filed by defendant Jamie Markey is fat. 9 pages in length and 66 pages of exhibits attached. Exhibit A, letter from Ty Beard to Jamie Markey, takedown letter. Exhibit B, deposition of Victor Mignogna, Mignogna deposition. Exhibit C, declaration of Jamie Markey, Markey declaration. Exhibit C1, letter to Jamie Markey from unknown individuap. Individuap? What's an individuap? Exhibit D, tweet by Stan Dolan. Dolan tweet. Exhibit E, examples of Damn It Nick t-shirt. Damn It Nick shirt. Make sure you buy a Damn It Nick shirt. Make sure you buy it. Oh my God. Exhibit F, photographs of plaintiff, counsel, and Nick Rekieta. Team photos. They called it team photos. Like we're an anime. Squad up. Oh God. The next time I see Vic, I'm going to Naruto run into his arms for a photo op. Exhibit G, declaration of Sam Johnson. And Exhibit G1, engagement letter. The brief in support of sanctions and attorney's fees pursuant to Texas Citizens Participation Act filed by defendants Monica Rial and Ron Toye is 13 pages in length. It's 286 pages of exhibits attached. Exhibit 1, screenshots from Kiwi Farms. Exhibit 2, obituary of Lewis Walter Owen. No one can figure out what the obituary of my grandfather has to do with any of this. Exhibit 3, online article from MCD Mag about the Lewis and Peaches Owen Heart Hospital. By the way, if you're in East Texas and you have a heart condition, I strongly recommend going to the Lewis and Peaches Owen Heart Hospital. It is state of the art. It is one of the best heart hospitals in the entire country, and certainly the best heart hospital in East Texas. And there's a lovely chapel in there where if you are of a religious bent, you can go ahead and offer your prayers to your chosen deity. Although I think the chapel skews Catholic, but I'm sure other faiths would be welcome to borrow some Catholic time and pray inside that chapel. Mythos Irving says, this is my penance for making y'all sick. I must be suffering from West Nile. That was disgusting. Thank you. Exhibit 4, last will and testament of Lewis Walter Owen. Exhibit 5, certificate of formation for Rekieta Media. Rekieta Media, LLC, a Texas limited liability company. Exhibit 5, certificate of formation. Oh, wait, I read that. Exhibit 6, screenshots from the Kiwi Farms. Exhibit 7, online article from CBR, an absolute dumpster of a publication, entitled The Vic Mignogna Lawsuit Failed, but Fan Rage Made It Worse. Exhibit 8, online article from Minnesota Lawyer entitled Minnesota Attorney Plays Soldier's Role in Anime War. You missed my online hate factory article. I want to know what's in it, but I don't want to pay. I got to go pick one up from the garbage can. Minnesota Lawyer, you can find in the garbage can of any Minnesota law office. So I need to go to a local law office and scour their garbage can for Minnesota Lawyer and steal it from them. Also poop in their bathroom. Exhibit 9, email dated September 6, 2019 from unknown sender to webmaster@tarrantcounty.com along with screenshots from unknown individuals. Exhibit 10, screenshot of GoFundMe. Woo, woo, woo. GoFundMe is mentioned. We are now at $265,603. Look at the 8s rolling in. We got Quayshawn Furman. Come on! Matt King, Faisal Al-Gadir, CJ Evan Henderson again. These were already read. This is just so recent. Thank you so much. Thank you guys. Oh man, where are we? This one? All right. Email. Oh wait, we read that. Exhibit 11. Affidavit of J. Sean Lemoyne. JSL Exhibit C to affidavit biographies from Wick, Phillips, Gould, and Martin LLP for J. Sean Lemoyne, Ethan Minshall, Jeff Mills, Jeffrey Hellberg Jr., and Zachary Farrar. Affidavit of Casey Eric. Exhibit A, order granting defendant's motion dismissed under TCPA. Exhibit B, biography from Cowles Thompson of Casey Eric. Exhibit E, cost report. Affidavits of Andrea Perez, by far the most attractive lawyer on the legal teams. Exhibit A, redacted invoices from Carrington Coleman, and Exhibit B, biography from Carrington Coleman of Andrea Perez. Exhibit 14, notice of deposition dated April 25th, 2019 for plaintiff. Like, I'm sorry, Bullock, but she's prettier than you are. There you go. For the following reasons. Oh, wait, that's disingenuous. That's disingenuous. That's a disservice to Carrie Christie, who is beautiful as well. I was forgetting that Carrie Christie was an attorney in the case, and my humblest apologies. I will mark it a tie. For the following reasons, the following exhibits attached to the motions and brief in support of sanctions and attorney's fees should be struck from the record and or not considered by this honorable court. Hey, by the way, Jamie Markey, I bet no one accosts Andrea Perez when she walks around into random 7-Elevens. Just saying. I bet none of them are yelling angry things at her. The affidavits of John Volney at Exhibit 1 from Defendant Funimation Productions, LLC, Jay Sean Lemoyne at Exhibit 11, Casey Eric at Exhibit 12, and Andrea Perez at Exhibit 13 from Defendants Monica Rial Rantoye, along with the declaration of Sam Johnson at Exhibit G from Defendant Jamie Markey, are inadmissible because not only did the affidavit's declaration lack foundation, they're hearsay evidence under Texas Rules of Evidence Rule 801 and 802, and they violate Texas Rules of Evidence Rule 902, 10b2, and 6, and are therefore inadmissible. I'm not going to look into this. I would suggest that their affidavits and declarations are probably not inadmissible hearsay, but I don't know. Maybe maybe they'll flesh out that argument. Arctic Pride says, wishing all in the chat and the Rekietas a happy Thanksgiving and a good night. Thankful for the quality time I've come to spend here. Hope all y'all get to enjoy it with your loved ones. Yeah, man. Happy Thanksgiving to you and good night, buddy. Screenshots of law firms' websites with the biographies, resumes of John Volney and Christian Orozco at Exhibits 1A and 1B. Jay Sean Lemoyne, Ethan Minshall, Jeff Mills, Jeffrey Helberg, and Zachary Farrar at JSL Exhibit C to affidavit. Casey Eric at Exhibit B of Exhibit 12 and Andrea Perez Exhibit B to Exhibit 13 are hearsay under Texas Rules of Evidence 801 and 802. Violate Rules of Evidence Rule 104 and 901 regarding authentication of electronic evidence. Violate the Best Evidence Rule under Texas Rule of Evidence 1004, thereby making them inadmissible. Chup does not seem hip to rule any evidence inadmissible except for stuff against Vic. So I'm not going to, I'm more curious about some reasoning that might be present in here. We'll see. Exhibit 1, this is the unofficial copy. This is the one I got from the website. Why is it unofficial? Exhibit 1F from Defendant Funimation Productions, LLC is hearsay under Texas Rules of Evidence 801 and 802 and is irrelevant to the court's determination of sanctions and attorney's fees, along with being harassing and included as a means to attempt to prejudice plaintiff with the court making these exhibits inadmissible. What was 1F? Is that from Funimation? Oh, transcripts of excerpts from YouTube live stream. That's what that was. That was 1F. Wait, no, where was 1F? F! Here we go. Exhibit 1G from Defendant Funimation Productions. Exhibit 1 and Exhibit 6 from Defendants Monica Rial and Rantoye. And Exhibit D, Exhibit E from Defendant Jamie Markey are hearsay under the Texas Rules of Evidence 801 and Rule 802. They violate Texas Rules of Evidence 104 and 901 regarding authentication of electronic evidence. They're not only irrelevant to the court's determination of sanctions and attorney's fees, but are harassing and included as a means to attempt to prejudice plaintiff with the court, making these exhibits inadmissible. Chup may refer back to this. I don't know if he will, but he may actually rule those inadmissible. He could strike those things. We're talking about the will and trust, or the will and the last will and testament, the obituary, the YouTube stuff. Chup didn't seem too interested in the YouTube stuff at all. So he may actually use this as a foundation to strike that reasoning. Exhibit F from Jamie Markey is hearsay under Texas rules of evidence. Violates the best evidence rule. Is also harassing. What was F for Markey? Press F for Markey. Oh, that's the photograph. That's the Chad photo of the cigar smoking. Can't wait to smoke cigars with those guys again. Man, it pissed people off. Remember when I was going to get arrested for smoking in a designated smoking area? Remember when that was the thing? La, 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 he's going to get arrested. It's a smoking area, you idiot. Oh, I keep losing my place. Oh, here we go. Exhibit 9 from Monica Rial Rontoya and Exhibit C1 and Exhibit C from Defendant Jamie Markey are both hearsay under Texas rule of evidence. Lack foundation are irrelevant to the court's determination of sanctions and fees, along with being harassing and including as a means to attempt to prejudice plaintiff with the court making these exhibits inadmissible. Exhibits 3, 7, and 8 from defendants Monica Rial and Rontoya are hearsay under the rules. Lack foundation are irrelevant to the determination, harassing and included, blah, blah, blah. Exhibit 2 and 4 from defendants Rial and Toye are hearsay. Lack foundation means prejudice plaintiff. These two exhibits are particularly egregious and offensive because they include information about a person who is not a party to this lawsuit and reference the deceased grandfather of a person who is not a party to this lawsuit. So that's the will and testament and the obituary and the whatchamacallit, the article. Let's get to the argument here. For the affidavits of John Volney at Exhibit 1 from defendant, Funimation Productions, LLC. J. Sean Lemoyne at Exhibit 11, Casey Eric at Exhibit 12, and Andrea Perez at Exhibit 13 from defendants Monica Rial and Rontoya, along with declaration of Sam Johnson at Exhibit G from defendant Markey. The affidavits' declarations lack foundation to the extent that each of the affidavits and declarations attempt to establish a reasonable attorney fee or the amount of said fees. They are hearsay pursuant to the rules because they are being used, quote, to prove the truth of the matter asserted, which is to prove that each attorney generated attorney's fees while working on this matter, and thus they are inadmissible as evidence. Interesting play. It is weird because the attorneys are not parties, so they're not subject necessarily to an exception, but to the hearsay requirement based on being a party statement. However, they are business records. Now, the alternative argument would be that business records exemptions to hearsay require a specific filing in Texas to generate a business record affidavit that they didn't do. The affidavit's declarations violated Rule 902.10b2, which requires the statement attached are blank pages of records. That's the business records affidavit rule, I believe. John Volney, J. Sean Lemoyne, Casey Eric, Andrea Perez, and Sam Johnson all state true and correct copies and or original records are exact duplicates, but not one includes the required statutory language of the exact number of pages of records. In addition, neither J. Sean Lemoyne, Casey Eric, Andrea Perez, or Sam Johnson have included the required statutory language from Texas Rule of Evidence 902.10b6 that states it is the regular practice of the business activity to make the records. Absence this language, none of the affidavit's declarations can be authenticated, and thus they're inadmissible. Again, this might be a valid legal argument, but Chup doesn't seem keen on using this valid legal argument. So, we'll see. The screenshot from firm websites of the biographies, resumes of John Volney and Christian Orozco. All of these people, I'm going to just say all these hoes, are hearsay under Texas Rule of Evidence 801 and 802 because they're out-of-court statements made to prove the truth of the matter asserted, which is that each individual is an attorney and has qualifications in an attempt to justify the large amount of attorney's fees being claimed and requested making those records inadmissible. Yeah, this isn't going to fly. Collectively, they violate Texas Rules of Evidence 104 and 901 regarding authentication of electronic evidence. There's screenshots of websites that do not indicate who authored these biographies and resumes. Well, actually, again, another technical legal argument that I think Chup is largely going to ignore. If the information included is accurate and correct, and therefore they lack proper foundation for relevance and admissibility, with authentication being a condition precedent of admissibility, the inability to authenticate these screenshots of law firm websites makes these biographies inadmissible. Finally, these screenshots of the biographies violate the best evidence rule. In addition, each attorney could have attached an original resume, which is located in their offices, but failed to do so, thereby making these records inadmissible. Yeah, again, I don't see Chuck sustaining these objections, but you got to make them because now they're in a chicken shit war and everything has to be a bitter back and forth. Ty gets some criticism, and maybe it's correct. I don't know. It's criticism, right? Ty gets some criticism for being too nice to defendant's counsel throughout the thing. I'm gonna wager that niceness is gone. Hey, Funimation. I hope you're ready to be deposed. I hope you're ready to be deposed. Because I think the gloves are off. If you think the depositions of Monica and Ron went poorly, oh God, I hope some of your executives get deposed. All right, Exhibit 1G from defendant. A bunch of exhibits from a bunch of people. Screenshots of websites of statements made out of court and are being offered to prove the truth of the matter. That sanctions should be awarded against plaintiff for the actions of people who plaintiff associates with. These exhibits also violate the authentication rules and electronic evidence. They are screenshots of websites that do not indicate who authored them. If the information included is accurate and correct, they lack proper foundation of relevance and admissibility. Same thing. In addition, these screenshots are not only irrelevant to the court's determination of sanctions and attorney's fees, but are harassing, included to attempt to prejudice plaintiff with the court, making these exhibits inadmissible. Exhibit F from Markey is hearsay. Oh, Sabbath deposition? Oh, God. Oh, God. How many women have you had sex with that aren't your wife? How many women have you offered a role to in exchange for sexual intercourse? Sexual favors? It depends on your definition of the word is. I did not have sex with that woman. Not a single time. Not once. Apache Chief says, just got home from drinking and brought you up to a lawyer in New York City. They laughed and knew who you were and thought all of this was some horse shit. I enjoyed that. Now I'm going to bed. Happy Thanksgiving. Oh man, that's weird. That's weird. Hopefully he thought I was a terrible person. Okay. A whole bunch of stuff. Photos. Here we go. These photos are out of court statements, do not made to prove the truth of the matter asserted by defendants. They violate the rules 104 and 901. And they lack foundation of what is being shown, and no way to know if these photos and pictures have been photoshopped by a third party, and therefore they lack proper foundation of relevance and admissibility. In addition, these photos are not only irrelevant, but harassing intended as a mean to prejudice plaintiff. Exhibit 9, so this is a subheading here. These are the photos. Exhibit 9 from defendants, Monica Rial, Ron Toya, and Exhibit C1 of Exhibit C from Markey, both hearsay, because they're an email from an unidentified person and a letter from an unidentified person, which are out-of-court statements used to prove that plaintiff caused people to initiate threats against others, including the court. Not only is this argument flawed and ridiculous on the part of defendants, but it is clearly hearsay within the definition of the Texas Rules of Evidence. Both exhibits lack proper foundation, cannot be properly authenticated because the person who sent this email and letter are unidentified. No defendant provides the proof needed to properly authenticate them, particularly the letter that defendant Jamie Markey claims is a threat against her, because without a handwriting expert or the letter being signed, there's no way to know if this letter is fake. Oh no, they called you a fake, Markey. They implicitly accuse her of lying about death threats. I mean, of course she's lying about death threats. No one knows of a harpoon long enough to penetrate the blubber layer. But of course she's lying about death threats. Finally, these exhibits are irrelevant to the court's determination of sanctions and attorney's fees because threats from anonymous people that can't be verified have not caused attorney's fees to be generated. These exhibits, along with being harassed, are included to attempt to prejudice plaintiff with the court, making them inadmissible. Exhibits 3, 7, 8 from defendants Rial and Toye are hearsay under the rules of evidence because they're online articles being used to prove the truth of the matter. By these defendants that any fan rage has been caused by the plaintiff, thereby justifying an outrageous amount requested for sanctions against plaintiff. And to prove the defendant's totally incredible conspiracy that Lewis Owen, deceased grandfather of a non-party, is wealthy and thus somehow a non-party's grandfather's wealth should be considered when ordering sanctions against plaintiff. These articles lack proper foundation because there's no way to authenticate if these articles are a true and accurate reflection. Who authored these articles? What date the articles were written? If these articles are real or fake, created by defendants. Furthermore, these online articles are irrelevant to the court's determination of sanctions and attorney's fees because fans being enraged by the defendants or the court is not controlled by the plaintiff. And to suggest otherwise is insane and an illogical argument. These online articles, along with being harassed to plaintiff, opposing counsel, and non-parties are included as a means to attempt to prejudice plaintiff. Yes, of course. Exhibit 2 and 4 from defendants Rial and Toye are hearsay under Texas Rules of Evidence 801 and 802 because the obituary and last will and testament of a non-party who is deceased are out-of-court statements being used by defendants to argue the court that a deceased person's wealth and the fact that this upstanding philanthropic human being who is revered in Tyler, Texas, happens to be the grandfather of a non-party who is the target of defendants' rage should have this wealth consideration when the court determines if sanctions should be awarded against plaintiff. Exhibit 2 lacks proper foundation because it is a screenshot of an obituary on a website and, as discussed previously, is incapable of being properly authenticated by defendants. There's no way to know if the obituary is a true and accurate copy, if this website is a secure website, or who authored the obituary. Both exhibits 2 and 4 are irrelevant to the court's determination of sanctions and attorney's fees because a non-party's wealth should not be used to determine if plaintiff should pay sanctions. Both exhibits, along with being harassing to plaintiff, who never knew this person, co-counsel, and a non-party, are included as a means to attempt to prejudice plaintiff with the court, making these exhibits inadmissible. These 2 exhibits are particularly heinous and offensive because they include information about a person who is not a party to the lawsuit and reference the deceased grandfather of a person who is not a party to this lawsuit in an attempt to create some far-fetched conspiracy to justify awarding attorney's fees and to order plaintiff to pay sanctions. So there you go. That's their attack on this. I thought they might attack the billing more in this rather than just their exhibits. But yeah, that's that. Oh boy. Oh boy. So we'll see. Chup now has to do a finding of fact and conclusion of law. And interestingly, he was presented with an objection and motion to strike that he has not explicitly ruled on, and can certainly draw on this handy-dandy guide when making his findings of fact and conclusions of law. He can go ahead and strike things. That's the interesting thing here. By Lemoyne requesting that Chup issue this finding of fact and conclusion of law, Chup can now go back to this document, which he has not explicitly ruled on, and he can borrow a bunch of justifications right here for his outcome. He can just sustain these objections. These are irrelevant. And they're good objections. They're objections that I don't think Chup would normally consider. But Chup now has the ability to go ahead and strike a whole bunch of stuff. Right here. This is irrelevant, this is irrelevant, this is irrelevant. Struck it. Paired the... I found that these filings by the defendants to be irrelevant. Now I've pared down the attorney's fee award and sanctions award accordingly. Someone thinks Therese is attractive? Oh my God, get that person psychological help immediately. Isn't Therese a kid diddler or whatever? Oh my God. Gross. Oh. 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 All right. I don't want to read the response to Funimation tonight. It's getting too late to do that. I want to go through super chats, and then I got a broth brewing upstairs. I made a turkey earlier. A turkey you could have watched being prepared if you're a member of the Rekieta Law Discord. Or New Project 2. You could have watched it live, participated in the chat during the live thing, which was an absolute disaster, perfectly boomered. But I made a turkey earlier, and then since that turkey was done, I used some of the carcass and the neck and stuff like that to make a broth, which I will use to make the gravy for the turkey dinner I make tomorrow. That's how first world we are. I am making 2 turkeys for Thanksgiving. The first one is existing almost solely to provide the materials for the broth for the gravy that I'm making tomorrow. Marsupial Gamer, subscription to Twitch does not currently qualify for Discord link, mainly because a subscription to Twitch, while it costs $5 to you, amounts to half of that to me, and I don't find that fair with the new Project 2 and Patreon subscribers. It's not the same level of involvement. So no, not at present. That may be something I change in the future, but right now the Discord is limited to Patreon and new Project 2 subscribers. So there you go. All right. But do come subscribe on Twitch if you so desire. I love the Twitch show. It's completely different than this. Very relaxed and chill. I don't call nearly as many people as I want to fat. And I'm soon going to start a Ranger Spencer campaign in either Pathfinder Kingmaker or Neverwinter Nights, where his hated races are all half-breeds because he's against miscegenating and orcs and maybe goblins, if I have enough hated races to go around. And he will be compelled to kill those races as soon as possible. So that will be Ranger Spencer in either Neverwinter Nights or Pathfinder Kingmaker. I haven't decided yet, but he'll be a racist asshole, which is allowed. Rangers are race haters in the game. It's not me, it's the game. So there you go. So all right, guys, let's I'm gonna go through super chats now. Thank you all for participating. Let's do one more check of the GoFundMe. I'm lying. I'm going to do 2 more checks. I'm going to do 1 check before super chats, and just in case anyone wants to contribute in the meanwhile, I'm going to do 1 check after super chats. We've got Matt Williams. Thank you for your donation of $8. Lots of 8s there, Funimation, for a middle of the night live stream. That's not a good look for you. It's not a good look for you. This is the final check of the library fund. We're at $12,260. Thank you to Hawk Anime for the contribution. I mean, guys, Keith is going to be blown away. I can't wait to bring him back on so he can basically cry like a man baby on the show and offer his thank you to you guys personally. So I'll announce it as soon as possible. Friday will be the Big Brain panel. Don't miss it. It should be fun. A Black Friday Big Brain panel. That's the best Black Friday deal I can possibly offer. All right, guys. Actually, I may have some Black Friday codes for Teespring. I'll see if I can get a How Embarrassing shirt up and a discount code for Black Friday for Teespring. Just for you. Because I love you. And those discount codes come out of my pocket, but I love you and I respect you. And so I will share those on Black Friday. On Black Friday. Assuming Black Friday isn't shot by the police before we get to it. Okay, let's get to these. Let's get to these super chats and justice chats. There we go. Hellsnake. Hellsnake says, 7-Eleven employees probably thought she was a hooker who stiffed someone. Oof. Oof. As Cybertest says, Nick's bank statement. This is fine. Night of Hopex says, what universe does this fat bitch live in to think that a gas station clerk has a duty to act on her behalf? How insane can one filthy D-sucking hoe be? I don't know. Bad Dragonite says, Duchette has me blocked and still felt the need to quote tweet me. Loving this cheap-ass rental space in his head. It's very spacious in here. It is very spacious in Greg Doucette's head. Also spacious in his neck fat. As Cybertaz says, they attack, but do they really matter? No. Hated 7DTD says, just watch the Ultramarines movie. How true is it to lore? It's pretty good. They got slaughtered like lemmings. Well, chaos. Chaos is devastating. They were so green, they should have been orcs. That's true. That's true. But the Imperium does suffer defeat with frequency. It gets redacted. Magnus Borson says you should post an update explaining the $8 donos. I think I will. Good job. Crusader Saris. Oh, wait. Hated 7DTD says, just got out of the gym, catching up at 2x speed. So glad I understand you. Easily understand you still. That's intentional. I am a trained professional who is understandable both at normal speed and double speed. Crusader Saracen says, Nick, it's not not November. When you're married, it's knock her up November. And you still have a few days to get to it. So get to it. No. 5 is enough for us. 5 is enough for us. Bad Dragonite says, any word on the Ian Corzine Kappa thing? No, he hasn't responded to me yet. So maybe he thinks I'm a racist. Crusader Saracen says, every time Lamar writes something, all I can see is Dr. Seuss's classic children's book, Horton Here's a Bitch-Ass Liar. Crusader Saracen also says, if at least just one of the cause of actions overturned appeals, how hard would the defendant's Discovery FF games come to bite them in the ass? Well, it depends on if that is against Monica and Rial and Rontoye. Could info found in Discovery be used to bring the other defendants back into the suit? No. No. If they're dismissed with prejudice and it's upheld on appeals, no. They cannot be brought back into the suit. They could be brought into a new suit if it was a new claim. But it'd have to be entirely separate. So it'd have to be something entirely new, which is possible. E1337 Neo says, hey, Nick, happy Thanksgiving. Hey, back at you. By the way, I met Chris Sabat at Pensacon earlier this year and shook his hand. Decision I'm deeply regretting given the whole casting couch thing. Man, I hope you didn't get AIDS from the handshake. I'm sorry. Make sure you get checked. No telling where that hand has been. No telling who is forced to endure the hand. And then Hugh says, Therese looks like the love child of a goblin and a Cabbage Patch doll. Harsh but fair. All right. Let's get back to the super chats. The Agrolith. Pin my boomer stamps on your last video, you geriatric. I thought they did get pinned. I thought your boomer stamps did get pinned on the last video. Go back and check. I think if it didn't happen, I'll make my archive do it. Nicker Jim says boomer. And then says, take my free YouTube money. Also late and gay. He also says, golly gee, I sure do love ad block. Rude. And says, last one, Epstein didn't kill himself. We've also got S. Steele says, $5 to you, mate. Hey, thanks, buddy. Kimberly Moriarty says, I'll listen tomorrow while cooking. Happy Turkey Day. Man, I got a 5-hour cook in front of me on Thanksgiving. What do you got, buddy? Ma'am, sir, I don't know. Mr. Leon says, take my free YouTube super chat with pleasure and prejudice. Trucid 2 says, free YouTube money, don't read, please. F. Dark Foxen says, to point out how amazing this chat is, I did the math. 144 people donated $10,850 to the library. That's an average of $75 per person. Reaver Barish says, nothing better than free super chats for rackets. Thank you. Jared Chi says, thank you again, Nick, for bringing these entertaining and informative streams. My pleasure. Chris Shotwell says, here are my last 2 free super chats. Enjoy. Thank you so much. Kyle Bishop says, think we should watch how defendants' legal fees escalate through appeals and see if it keeps up with the GoFundMe. Yeah, I don't think Lemoyne will be able to help himself. He can't help himself out of a bathtub. How could he help himself here? John says, love the show. Hey, thanks, John. Love you back, buddy. Reaver Barash says, sucks that Vic had to go through this BS for your channel to get recommended to me and then to get to Masterson and Q because of you. Bad stuff for good stuff. That's how it goes, man. How it goes. When life gives you lemons, you drink Lemoyniade. John says, all the free super chats. Thank you, John. Reaver Barash says, more free YouTube money. That guy says, Antifa equals Nellie Olison. John says, happy Thanksgiving, everyone. Chris Shotwell says, hope you and your family have a wonderful Thanksgiving. And also, happy Thanksgiving to all fellow I Stand With Vic out there Reaver Barish says, last free super chat. Thanks for all the content, Nick. It's my pleasure. It really is. Vidin the Cold One, thanks for the weird little thumbs up bird. Travis Mears says, don't mind me, just spreading a good day to you, Vic and Mr. W. Have a good one. Thanks, buddy. I really appreciate it. Ruby Stone says, I bet Jamie's the type of person who wants to be called a women instead of a woman. Seriously, though, thank you for your involvement in all this. It's my pleasure. Ray Drake says, Epstein didn't 7-Eleven himself. Halo Millennium says, Jamie's Bush did 7-Eleven. Oh, God. Whew. SJW Slayer Leo says, can you see the info of those who super chat you? I addressed this earlier. No, I cannot. Jason of the Great Awakening says, so sad that no one wants to protect the evil communists entitled Whammons anymore. I love it. They hate men. They legitimately hate men. They think all men are sexually harassing them until a different man is accosting them, and then they want a man to save them. It's embarrassing. Dorby says, we're missing some context on that 7-Eleven story. Oh, do you think Jamie would offer a story out of context? No. SJW Slayer Leo says, regarding Marky's story, he's not wrong, though. Ouch. Ouch. Ike 113D says, anybody else hear about that AIDS positive sperm bank? Weird, right? I did not. That sounds horrible. Ash Ukihime says, Brian, hey, Nick, happy Thanksgiving to you and your family. Yeah, you too. You too. Mike Tinsley says, would we be able to donate manga to the library? Maybe. Email me about that and I'll ask Keith personally. S Cybertaz says, and the guard's name was Hillary Hinton. Malachi Tomlinson says, Grumps Burgers and Inthix Burleson Celeburn Addison. I don't know what that means. Lupin Rager Joker says, keep up the good work, Nick. Hope you and the family have a good, happy Thanksgiving. Or have a happy Thanksgiving. Did you ever get to see Godzilla King of Monsters yet? No, I have not. I have not. I want to. Ike13D says, I'm giving away super chats because I feel like it. Attaboy. Stars Girl Forever says, happy Thanksgiving, Nick and the chat. Enjoy the day. The guy from that thing says, Nick, this is getting old. I get it, but I'm bored. I'm sorry, buddy. Sorry you're bored. Legal reading is boring. Zinka Ruka says, thanks for the donations. Lupin Rager Joker says, hey, Nick, are you or have you ever been a fan of pro wrestling? And if so, who are your favorite wrestlers? Yes, and only Stone Cold Steve Austin. Because he sprayed beer all over that one chick and you can't do it anymore. Vernie S, thank you for the donations. Austin Heartless says, I finally have some spare money. Oh, and I'm also, of course, a fan of the lingerie episodes that they used to do live. Because cheap live breast shots are perfect. Austin Heartless says, I finally have some spare money and now I have to decide between selfish Black Friday shopping and donating to the GoFundMe. Do selfish Black Friday shopping, buddy. The GoFundMe will be around for plenty of time. Duden2217 says, happy Thanksgiving, Nick. Thanks for doing what you do. I first found your channel via Meyer vs. Wade and stuck around for Vic. Hashtag malice bitch. Meyer vs. Wade, I check every single day. It costs me 30 cents a day to check for a ruling, and there isn't one yet. I will cover it as soon as it's out. Max Payne Fan 2010 says, I recently found out Tara Strong stopped following Vic on Twitter. That's too bad. And then says, wait, I'm wrong. Sorry. Oh, I guess it's not too bad. Justin Frazier says, proud of you guys. While Kick Vic looks into renting billboard space to slander Vic further, we rose over $10,000 for books to go to children who need them. Thank you. Vernia says, Nick's Lemoyne voice must be the voice of God. Rural says, sluts. Asmodea says, Galaga Chew, La Magica Boo, your glass is now filled with Monica's goo. Oh, goo. Note to self, always read ahead. Oh my God. EEF says, think Chup set amount after Vic destroyed them. Billy the Kid Lawrence says, fellow Racketeers, no obligation. I thought I'd share the GoFundMe for my mother. Funds running low. Hashtag Candy Crushes Cancer on GoFundMe. First result on Google. Guys, check out Candy Crushes Cancer on GoFundMe. If you're moved to help someone who has a mother dealing with cancer, is very expensive. Absurdly expensive to deal with, and they could use your help. So if you want to check that out, please do. Reno McDallas says, have a wonderful Turkey Day, Nick and chat. Just remember, Macho Man Randy Savage, elbow drop noobs for your sins. Oh, yeah. Silent Sin says, Merry Xmas. Haha, just kidding. A Deadly Assassin says, help him, GoFundMe. Tyler Creeder Funeral, Illinois. If you want to check out Tyler Creeder, Krieter Funeral in Illinois, you can check that out if you want to help out. Mike M says, so I just noticed on Ty's website, used to be Beard Harris Bullock and Hughes, but is now Beard Harris Bullock and Christie. What happened to Hughes? When did Christie become a partner? That's awesome. What happened to Hughes? My understanding, I don't know specifically. My understanding is Mr. Hughes accepted an offer at a different firm, but I don't know that specifically. When did Christie become partner? Probably around the time that Hughes left, but I don't know. I'm not on the team there. So Anime Dropouts says, happy Thanksgiving, everyone. If any of you are into anime, my channel Anime Dropouts has podcasts and anime inspired drinks. Plus I'm going to review an anime MILF coloring book next month. Thanks. That sounds fantastic. Notorious Ree, happy Thanksgiving. Back at you, buddy. Name says, I had some good burgers in my time. I love a good Swiss, melted Swiss cheese, roasted mushroom, and caramelized onions on a burger. That is hot stuff. You can get it at a number of different places. I don't get the meme, but you guys do you. Siren Jag says, hey, everybody, hit the thumbs up button. If we get to 1,000 likes, I will officially call it Black Face Friday. D-Man DOG056 says, by the way, do hit the like button. D-Man GOG56 says, ever see End of Watch? Good cop movie. No, I haven't. I wanted to watch it. I just haven't gotten around to it. Cowboy FMJ91 says, have the last of my googly dollars. Thank you. Mark Mariansky says, first time watch start to finish. Nick and Chad, happy Thanksgiving. Going to sleep because playing football tomorrow. Hey, good luck playing football. Enjoy it, buddy. Kilroy was here. Says, you did see Godzilla King of Monsters. He just changed his name to Jamie Markey. Mike Testa says, wait, Tara Strong is Kick Vic. Did I hear that right? Apparently he was wrong on that. So do not read into that currently. Let's get the outro playing. There's a couple Justice chats remaining. We got TLJ Screwjob says, what about Sabbath, Rooster Teeth, A&N with the statutes for limitations coming up? Could they be sued for emotional damages or something like that, even if defamation expires? There's a whole lot of questions about that can't be answered without actual access to the evidence. Discovery rule is the evidence on defamation. When the discovery of the defamation occurs and the discovery of the damage related to it occurs, that's when the statute of limitation kicks in. We'll see. I don't know. Crusader Saracen is the final one. Says, hey Nick, how do you and the missus typically divide the workload on Thanksgiving or other big feasting holidays? I do the cooking. I'm the cook in the house, and that is great. She helps clean up. She gets the table ready. She gets the place settings ready. She makes sure there's not like laundry all over our living room because we're a family of 7 people and laundry is just literally everywhere. She does all the other stuff. I just cook and make sure that there is food for everybody. She makes sure that everybody has access to the food. So that's how we divvy it up. Thanks for all the entertainment and keep fighting the good fight, brother. Hey, back at you, buddy. And Mike Testa says, happy Thanksgiving, Nick. You mauling at the mall. I am not going to the mall. I do not go out on Black Friday, ever. All right, guys. Thank you so much. Come watch on Twitch if you so choose. We'll be pursuing on in Pathfinder Kingmaker, having a good time with it. Not sure how long we'll go, but I gotta go get some food. Peace. Happy Thanksgiving. I am legitimately thankful for all of you. Thank you so much. Oh, and one final look at the GoFundMe. We are at 265,624. Thank you for Carlos Pene, Quaishon Furman again. Thank you guys for your final last minute donations. You guys have a good night. Enjoy the weekend, or enjoy the holiday. I will announce if I'm streaming or not later. Have a good night. Peace. Peace.
So pour out an odd bag of Balmore Spirits flow as the ones who get unemployed. So pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the throng better than Nick. So pour out a glass for the ones who have passed to